Assalamualaikum and greetings. My name is Farah Insyirah, and today our group will present our analysis of the legal implication surrounding dealings in Malay Reserve Land. We'll examine statutory restrictions, landmark cases, economic impacts, and reforms needed to balance protection with development.
So the legal issues in this topic is lack of standardization in legal framework across states, and also Malay Reserve Land often remains underdeveloped as land owners cannot leverage their lands for loans or sell to higher bidding non-Malay investors. And these are the statutory provisions that are related to restriction on dealings involving Malay Reserve Land in Malaysia.
We have reviewed 5 cases in respect of transfer, lease, charge, and lien, where in the first case of Tan Hon Chek, it's held that a Malay who acquires a Malay reserve land before the declaration can transfer or charge the land to a non-Malay without the approval of the ruler in council. In the second case of Bebe Sakima, it's held that all procedures in declaring a Malay reserve land must be abided for it to be taken into effect. For the third case of Datuk Haji Nik Mahmud, it is held that non-Malays can lease Malay reserve lands. However, this is in limited periods only. As for the fourth case, which is Afin Bank, it is held that a Malay can charge his Malay reserve land to a non-Malay entity. As for the last case, in Life Paradise, it is the Court of Appeal held that it allows the caveat on the Malay reserve land by a non-Malay.
We would also like to talk about the economic and administrative challenges when it comes to Malay Reserve Land. We find that the restriction when it comes to the dealings of Malay Reserve Land actually causes a lot of economic and administrative challenges because these restrictions cause the Malay Reserve Land value to decrease exponentially compared to non-Malay Reserve Land. There are an article in 2021 written by Rosman who said that the value of non-Malay Reserve Land is actually 25% higher than those of Malay Reserve Land. And not just that, 70% of Malay Reserve Land is idle, especially those that are located inland, because usually developers are not interested in developing the land. Therefore, 70% of them remains idle, and some of them even was left to dust. And moving on, urban Malay Reserve Land, however, faces a higher or riskier acquisition risk under the Land Acquisition Act 1960. And because of the inconsistent state laws and inefficient land officers work or administrative work, it causes more disparities when it comes to Malay Reserve Land dealings. Next, we will talk about the recent developments that have been happening in Malaysia with regards to restrictions of dealings in when it comes to Malay Reserve Land. So for the first one is we look upon Pahang. As of December 2023, Pahang has mandated that any Malay Reserve Land related dealings require the approval of state authority. And not just that, every cancelled Malay Reserve Land also needed to be replaced with the same ratio as it was cancelled. The next one is the involvement, or rather the introduction of federal schemes. There are actually a few schemes introduced by the government, which is Program Residency Rakyat, which uses Malay Reserve Land for affordable Bumiputra housing. And the last one is digital governance, because now we can see that land systems are done electronically. Therefore, it actually allows a reduced amount of error, like in the case of Baby Sakina.
Meaning the effectiveness of the law regarding restrictions on dealings involving Malay Reserve Land in achieving its intended purposes, our group came into a conclusion that there are two aspects that we can see, which is the legal effectiveness of Malay Reserve Land restrictions and the legal weaknesses and enforcement gaps. As for the legal effectiveness, we can see that there are successes in preserving Malay ownership and there are judiciary enforcement. So that is the good thing. As for the legal weaknesses and the enforcement gaps, there are three things that we can see. Firstly, there is inconsistent state interpretations. Secondly, there is procedural deficiencies in MRL registrations, and there are indirect transfer mechanisms.
For analysis, the law on Malay Reserve Land is designed to ensure land stays within the Malay community. Transfers, lease, or charge involving non-Malays are generally restricted. However, in practice, courts have allowed certain exceptions. For example, in Tan Hong Chit and Lim Kin Wan, dealings by a non-Malay before land is gazetted as MRL were allowed. But once land is in Malay hands, further transactions need the ruler in council's approval. In Datuk Haji Nik Mahmud and Bank Islam, leasing MRL to non-Malays was allowed, but only for a limited period. And in Affin Bank and Jamaluddin case, charging MRL to financial institutions was permitted as long as ownership remained with Malays. These rulings show that the law balances land protection with economic practically, though not always clearly. Despite its good intentions, the law on MRL has several grey areas. In Tan Hong Chit, it's unclear exactly when and who needs to seek approval for transaction once land becomes MRL. In Bebe Sakima case, a procedural error meant the land wasn't considered MRL at all, showing how administrative mistakes can create confusion. In Datuk Nik Mahmud, in term limited period was not clearly defined, making it hard for investors to plan. And while in Affin Bank case allowed charging to banks, some argue this undermines the principle of keeping MRL fully within the Malay control. Finally, there is a legal uncertainty about what qualifies as a Malay company under the law. Should company with mixed ownership be allowed to deal in MRL? These gaps such as a need for clearer and more consistent legal definitions.
To conclude, we do find some strengths and weaknesses to Malay Reserve Land, particularly the restrictions of dealing. For the strengths part, definitely it safeguards the Malay rights over the lands, and it prevents large-scale alienation to non-Malays. However, in terms of the weaknesses, there are also things to consider, such as fragmented laws, procedural gaps, and low market value that cause the land to be stagnant. So, to some point, we do agree that the restrictions of dealings with regards to Malay Reserve Land, it is good, but at the same time, it also poses quite a few problems unless it is modernized in order to avoid this economic stagnation.
Lastly, our group is going to propose three recommendations. Firstly, standardize state MREs. Second, strengthen registration procedures. And thirdly, tighten indirect transfer restrictions. By proposing these recommendations, we are expecting these outcomes, which is to preserve MRE's original intent while addressing enforcement gaps. Secondly, balances Malay ownership protection with practical land use needs. And lastly, ensures laws remains effective in modern contexts. Lastly, our group is going to propose three recommendations. Firstly, standardize state MREs. Second, strengthen registration procedures. And thirdly, tighten indirect transfer restrictions. By proposing these recommendations, we are expecting these outcomes, which is to preserve MRE's original intent while addressing enforcement gaps.